Thank you, Corla, and can I thank the various members of the Dáil for contributing to the debate today. Largely positive, it must be said, and I want again thank in particular the members that are on the Oireachtas committee who facilitated the pre-led scrutiny to enable us to bring this into the Dáil before the summer recess. Deputy O'Reilly, and I acknowledge she had to go, but just to reply to some of the questions that she raised, she mentioned the issue of costs, and just to say that the cost will depend on the application, whether any element of it has to be referred to court. The bill also requires that the process advisors' fees are notified to the directors of a company in advance of the appointment of process advisor. The fees are also notified to the creditors of the company as part of the provision of information concerning proposed rescue system, and the creditors are entitled to question and object to any part of the plan, including the process advisor's fees. So I think there's protection secured there. The plan to produce a plan by 49 days. Can it be done earlier than this? I don't believe it can, because there is minimum requirements for notice during the various stages of the plan. And for each stage of the plan to get the required notice, that would only give 2 weeks at the end for the process advisor to actually bring forward a restructuring plan. And I think, to be fair, an advisor would need that time frame, and that's the reason why it was set at 49 days. The virtual meetings, she may have missed that, but that is an amendment there to allow virtual meetings take place. The issue in relation to liquidations, we're working, and the department is working on a plain English guidance book for employees to explain their entitlements in redundancy and liquidations as part of the plan of action, which has been signed up to, in fairness, by the Congress of Trade Unions. That will make sure that people can navigate this technical area and access the amendment, the information that's needed. Duffy Cahill was referenced to as well, and as I said, a plan of action has been established. It is being supported by the Irish Congress of Trade Unions, and we are addressing, and I think Deputy Murphy acknowledged, minor as the amendments are, but there are some amendments in relation to enhanced information, ensuring employees can sit on that governing body, and that has been addressed as part of this bill. Deputy O'Muraku mentioned some of the things that Deputy O'Reilly did, but he also made an issue in relation, or highlighted the issue of insurance, and I agree wholeheartedly with him. It was an issue that I was very vocal on when I was on the far side of the House, and to be fair, a lot of work has been done on this issue in the last 12 months. The judicial guidelines have been implemented, and the Minister with responsibility for the Personal Injuries Assessment Board, in the period since the guidelines have been introduced, 540 cases have been adjudicated by PIAB, and there has been in excess of a 50% reduction on average on the awards that have been issued, and in some instances as high as 74% of a reduction. The action plan on insurance reform, Taoiseach will be going to Cabinet with that before the summer recess to give an outline on every point of the action and where we are on it. The Small Business Aid Scheme, thank you for acknowledging it. Myself and Minister English spearheaded that in the department to ensure that businesses that fell through the cracks inadvertently were protected, and I'm glad that scheme seems to be working pretty well. The perjury legislation, a couple of people mentioned it, and I too just want to mention former Senator Pádraig O'Cady, who was instrumental in ensuring that piece of legislation was enacted, and he did it. He does deserve acknowledgement for that, and the government was happy to ensure it was enacted there a number of weeks ago. I don't accept, and I can't accept, I suppose, the criticism that this legislation is rushed. It was examined by the CLRG. 12 months ago, we asked the CLRG to do a programme of work and examine this. They did it. The people involved in that process were practitioners, businesses, the unions, academics. Subsequent to that, we had a lot of work done with the officials in my department and the Office of Attorney General. Subsequent to that, we went out for public consultation. We got 17 substantive submissions back in relation to this piece of legislation. And work continued in relation to how we could make sure that it was robust, constitutionally sound. And the bill is not totally new, because the bill is based on existing law. And we're simply streamlining existing law, and no one is any less protected. And it's interesting to note, Deputy Murphy, that you complimented the examinership process that was done in a week period on a Dáil recess being coming back, and it was okay, and it was good and internationally recognised, and it was good for the Goodman Group. But after a year's preparation, we're rushing a bill that's going to give protection to small and micro companies. That's what we're doing. We're giving, after a year, we're bringing through legislation and honouring a commitment to give small and micro companies that are viable the opportunity to restructure. And like, at least you sat in for the debate. Deputy Éireann was critical of what we were doing. We're critical about the time that's been allocated to the debate. Took 5 minutes of his 20 minutes to contribute to the debate and skips it off and then doesn't participate in it. What this is about is ensuring small, viable companies who has the opportunity to enter into a restructuring process that will protect that company and, more importantly, protect the jobs that are dependent on it. So I don't take the criticism in that the bill is rushed at all. Deputy Shanahan, I think, spoke next, and I thank him and the regional group of independents for their support of the bill. I suppose he mentioned a number of points, one being that ISME should be represented and should have a place on LEAF. I agree with him. I've made that point to both the Taoiseach and the Taoiseach, and I'll continue to make it. The antigen tests, again, I agree with it, and I've continuously said that internally in our own party. And it's worth noting that antigen testing is included in the return to work protocol that was published by our department, I think, in May of this year, and it does set out how it can be used in various workplaces, and it is being used, and it is being used well in workplaces, and I think it should be rolled out further. Mentioned the issue of the hospitality sector. We were all bitterly disappointed that we had to press the pause button earlier this week, but in acknowledgement to the difficulty that the hospitality sector are experiencing because of that pause button, there is enhanced support for the next number of weeks, and rightly so. The Taoiseach, the Taoiseach, the Minister for Health, the Minister Catherine Martin, met with various representative bodies on Wednesday of this week, and extensive work is ongoing to see can we come up with practical solutions that will help get them back open as soon as possible. And I've engaged with some of the representative bodies in relation to that, and there is a willingness there that we can come up with the solutions. But we have to be very cognizant of the fact that there is an issue in relation to a new variant, and we have to ensure that we protect the overall economy, but we have to ensure that we protect our health service, because I don't think anyone would like to see the health service experience and the difficulties that they've experienced in January again. Deputy Fitzmaurice made a number of points, and one of the points he asked specifically was in relation to revenue debt and the cent in the euro, I think. And just to say, like, every plan will vary plan to plan. So, but the one point I would say that revenue or any creditor must receive more than if the company went into liquidation, and that's in the best interest of creditors. So it will vary plan to plan, depending on what has been how the restructure is decided upon. You're right. You made the point in relation to small and micro businesses are the backbone of the economy. 788,000 jobs are in this sector of the economy. The businesses and the companies that can avail of this scheme is any business less than 50 people with an annual turnover of less than 12 million, and 98% of the companies on the CRO fall into that category. So that's another reason why it's important that we get this legislation enacted before the summer recess, because businesses are at risk of failure. Businesses are at risk of failure, and I don't think any business and the stakeholders that engaged in this certainly don't want to see this pushed out any longer than it should be. Sorry, there's just one further point, if I can, with the permission of the Cairn Deputy Murphy had a query in relation to owners' contracts, and in particular in relation to leases, and this is the same as the examinership process in terms of the repudiation and the treatment of leases, and it has two options. One option is similar to the examinership, going through the court process, and the second option is under the supervision of the insolvency practitioner, that they can come to a mutual agreement. And I think, and you're right to acknowledge, George's Street Arcade, I think, is what you acknowledged, for the manner in which that landlord engaged with their leasees. And while that was a very public display in terms of how it done, I know that there's many other landlords that has engaged very practically and reasonably with their leases, because they want to ensure that the business survives and they can continue to trade on. So look, thank you, Las Concorla. Thank the members for their contribution this evening, and I look forward to working with them constructively through the following further stages. But it is an urgency that we get this legislation enacted before the summer recess.
Thank you very much.